Dispute that someone who was guilty, say, or even had a restraining order, that domestic violence is dangerous.
200 some years ago, the problem of domestic violence was conceived very differently. People had a different understanding of the harm.
If we're still applying modern sensibilities, I don't really understand the historical framing.
The Supreme Court heard arguments Tuesday on whether a 1994 law that strips gun access from alleged domestic abusers is constitutional. The Justice Department is fighting to uphold the law after an appeals court struck it down earlier this year. But the case could also bring much-needed clarity to the court's interpretation of the Second Amendment. CBS News chief legal correspondent Jan Crawford reports.
The real fear of losing your life when you leave is real. It's a real fear.
Ruth Glenn is head of a national advocacy group for victims of domestic violence. She also is a survivor.
Eventually, he later found me a few weeks later and shot me 3 times and left me for dead.
Her organization was one of many today urging the Supreme Court to uphold a 30-year-old federal law banning guns for people under restraining orders for domestic violence, like defendant Zaki Rahimi. Rahimi, under a protective order for assaulting and threatening to shoot his ex-girlfriend, was convicted of violating the law after he was involved in several other alleged shooting incidents in Texas. In the Supreme Court today, his lawyer argued the law violated the Second Amendment right to keep and bear arms, prompting this exchange with Chief Justice John Roberts.
You don't have any doubt that your client's a dangerous person, do you?
Your Honor, I would want to know what dangerous person means.
Well, I mean, someone who's shooting, at people, that's a good start.
Rahimi's argument could have wide-ranging implications for modern-day gun laws, as well as the system of background checks. Over the last 25 years, the law has stopped people under protective orders from buying guns about 78,000 times. The court seemed almost unanimously poised to keep it in place. Justice Elena Kagan.
You don't give guns to people who have the kind of history of domestic violence that your client has.
Ever since the Supreme Court ruled there's an individual right to bear arms, there has been a lot of confusion in the lower courts over what kind of gun laws are constitutional. This case could provide some much-needed guidance for some of those other gun regulations, including efforts to ban specific types of weapons. John?
Jan Crawford at the Supreme Court. Thank you, Jan. Let's bring in Jimmy Hoover. He's a Supreme Court reporter at the National Law Journal. Jimmy, you were inside the courtroom. What was the overall receptivity of the justices to both sides of the argument? Is it possible to tell? And was it, did they all behave the same way, or were there some interesting lines that appeared?
Well, thanks for having me, John. I would say that the overall kind of mood in the courtroom was one of sympathy towards the government's appeal in this case. You heard from U.S. Solicitor General Elizabeth Prelogar that this is a law that is very important in ferreting out domestic violence. She told the court that, oftentimes the difference between a battered woman and a dead woman is the presence of a gun in the household. And you saw a lot of skepticism towards the Mr. Rahimi's counsel in the case that this ran afoul of the Second Amendment. But really what this case provided is an opportunity for the court to clarify its 2022 decision in the Bruin case that vastly expanded Second Amendment rights and pretty much changed the way courts around the country handle these challenges to gun laws.
And let me ask you about that, because Justice Ketanji Brown Jackson in the clip we played seemed to be making some inroads in that area, which is to say this interpretation of the historical reading of the Second Amendment. What was she going after, and how might that change this broader interpretation of the right to bear arms?
Right. So in Bruin, the decision from last term, the court struck down this New York law on the basis that it wasn't in line with the nation's historical tradition of firearm regulation. And so a lot of courts around the country have been hearing these challenges to gun laws, and they've been going over the old law books and trying to see if there are kind of historical analogs, if there are similar laws from, the late 1700s or the early 1800s. And so what the Biden Department of Justice is asking the court to do is to say, No, you don't need an exact doppelganger law from those old days when domestic violence really wasn't something that society in general worried about. What you need is a broad principle, and the principle that the government argued was that it's okay to disarm people who pose a danger to society. So in that way, they say that this 1994 law disarming those who are under restraining orders for domestic violence fits within that tradition.
So then, does that open the door, if the court rules that way, do liberals hope that opens the door to what they've always argued, which is it's a living constitution? Going back and looking at the founders is too strict and doesn't comport with reality and modernity that we have it. Is that essentially the larger issue here?
There was certainly elements of that in the courtroom. I mean, you heard from Justice Ketanji Brown Jackson pushing back on the premise that really underlined the conservative majority's opinion in the Bruen case, saying, why should we be going back and looking at the kind of the country, frozen in amber, if you will, in the 18th century, when the Constitution really only protected the rights of white Protestant men, in her view. That's not necessarily the view that's held by the majority of the court. This is a 6-3 conservative majority on the court that does, at least in theory, subscribe to the idea that the Constitution should be interpreted according to its meaning at the time of its adoption. But at the same time, this is not a very sympathetic gun rights defendant here. I mean, this is a person that the lower court described as hardly a model citizen, has been as a well-documented history of criminal and violent activity, including multiple shootings. And so you saw some squeamishness on the part of even the conservative justices that were part of the Bruen majority of striking down this law.
Jimmy Hoover, Supreme Court reporter with the National Law Journal. Thanks so much.